Dash just texted 8:51.
Who do you want somebody to shoot first?
Let me check. Wait, no, wait, open. See. Put the mail in this place. I'm going to grab it out and put it in this. Let me show you. One, two. Just same time, right after. I don't know. Okay. Just let me know. I send you text back. Hold on. Ready yet? Stepchild. Yes. I'm a redhead.
Have you was a unicorn if you're a redhead? If you're an Asian redhead, you'd be a unicorn. So we're gonna dye his parents. Strawberry red. Okay. You can be a unicorn. You go for one.
Yeah.
Let me confirm.
This is all for you. Yeah, right. So much for 9 o'clock here.
Well, you also have that on a clock. It might be like 9:15.
How are you? How's the new job?
Okay, got it.
Can we let Ron Sullivan in? He's one of them, probably Frank Tassoni.
Appreciate it. 605.
All right, while we got time, we're gonna make a hot dogs.
All right, so according to CRB is on session, we just can't presiding. Mr. Sylvana Tano, we're not talking about calling services.
Thank you. Good morning.
May they be seated? Morning,
Good morning. Morning, Nora. Christina Stiffer on behalf of the state. Number 5 on court's calendar, Mario Fernandez Saldana, and number 6, Shanna Gardner.
Just got a second.
Good morning, Your Honor. Patrick Brody for Ms. Gardner, who's present, and Mr. Bias and Mr. Sullivan are on Zoom listening in.
Morning.
Good morning. Wait a minute.
That looks like a guy from Fields Automotive.
All right. Officer Cindy. Sir, turn your camera off, please. Officer Lynn.
I got you.
All right. Okay. Where's Mr. Bias?
Mr. Bias is in a place where
I
he's
thought
not
you
able
said he was
to.
on Zoom.
He's listening, Your Honor.
Oh, okay.
Yes, sorry about that, Judge.
Okay.
I will be speaking the least today, so,
All right. There is a gentleman from Fields Automotive, and that didn't look like you, okay?
no, it's not me.
All right, on my desk, there's, a defendant's motion to schedule evidentiary hearing memorandum of law.
Yes, Judge.
Obviously, it just got placed here, so I haven't read it. I was trying to read it quickly. You want to give me just a moment?
Yes, Judge, that's fine.
Okay.
the state's position on Ms. Gardner's motion?
Your Honor, my position remains as of the last court date. I do think she's entitled to a bond hearing on her motion. We're prepared to respond and prepared to have that hearing. I just believe that for the record's sake and for appellate purposes and to avoid prejudice to the state of Florida, we need to handle the disqualification motion prior to proceeding with our hearing. I've spoken with defense counsel this morning. I think we're close to requesting, I won't speak for them, I'll let them do that. We're close to requesting both the disqualification hearing. I've floated some dates with defense counsel. I'd be requesting we set the motions filed by defense regarding the disqualification the week of March 11th and Ms. Gardner's Arthur hearing the week of March 25th. And I think that's very reasonable given the amount of evidence the state's going to have to present to prepare, file our written response to their bond motion and handle this other pending matter.
All right, let me, first hear from you, Mr. Carter. What's your position?
Judge, I'm
Those
sure,
dates, on those dates.
Judge, I would need to speak to the other counsel involved in the case before I was able to confirm with the court.
Okay.
We've
Well,
asked.
I mean, as far as the way that I'm reading your motion to schedule an evidentiary hearing in the memorandum of law is that you believe that the state of Florida has had sufficient time. You wish to push forward, regardless of the court's ruling on a disqualification. Am I reading that incorrectly, or?
No, Judge, that's our position. And one of our major concerns is if we are successful on disqualification, we'd be back before the court with a new state attorney's office, and they'd be begging the court for more time to get up to speed on the case before they could have the evidentiary hearing. So it's our position, and our first available date is March 5th, and we'd ask for March 5th, Judge.
So I'm looking to essentially your second sentence in the second paragraph, which says, while the law is clear that a trial judge upon a motion to disqualify him or her, which that's not necessarily the case, you're asking to disqualify the state, must first rule on the motion for disqualification.
So, Judge, that was referencing a motion to disqualify the trial judge where it's an all stop and the judge can't rule on any other motions. There is no case law similar for a motion to disqualify the state attorney.
So it's your position that it is not an all stop.
That is our position, Judge.
With, are you taking into consideration what has been alleged against the state? And to me, it's a little bit different. So let's say it's the evidence that they potentially would produce to the court, which is one of my concerns about hearing any motion. That there's contested evidence, right? And then that would be presented in front of the court. That's what I don't know. Like, obviously I haven't seen it. I don't know. Do you have any of those concerns if we went forward with the bond hearing?
Judge, I have some concerns.
Based on your review?
But based on my review, I don't know any other way, Judge, because my client's been sitting in custody for a long time now. The state has had an awful long time to prepare for any evidentiary hearing on a bond. I mean, I think it's disingenuous for the state to say they need more time to prepare when they've already presented this case to a grand jury, and they're well aware of all the evidence out there. To our knowledge, they've completed all testing. So I wouldn't understand how they would need more time to prepare. But with regard to the the court's position about whether or not we have concerns, we do have concerns, but the alternative is that Ms. Gardner stays in custody until this disqualification issue is resolved. And I think, Judge, once you hear what we found out during the depositions this week, you're going to see that this is much, much bigger than any of us ever thought a week ago. And I can tell the court what happened.
Really?
Yes, Judge, I can tell the court what happened during the depositions this week if you would like to know.
So because you share in those concerns, right? And I'm concerned, and I've always been clear about that with the parties, right? Ever since you all filed this motion, with the court, to me, because there is no guidance, in a situation like this is probably, I don't know if it's a first impression, but at least it hasn't been litigated on an appellate level. It seems more practical, to me, to handle the disqualification. I'll give you the time. I'll make the time. If you all are prepared, I wanted to do it sooner rather than later, and then I could still honor all of the things that you put into this motion. I'll give, Ms. Gardner the hearing that she's entitled to.
Yes, Judge.
Right? But if you all have concerns about potential evidence that they would present in order to meet or not meet their burden, then I'd rather hear that out first. And I do understand the concern about getting up to speed. Let's say hypothetically I do disqualify the state attorney's office. I'm cognizant of that, but you know, the state should be able to burn the midnight oil in my mind and get that prepared. So
Your Honor, this is Jesse Dreiser on behalf of Mr. Fernandez, and we didn't do our now, and Mr. Hill is present, Mr. Tassoni as well. Your Honor, I don't know how clearly I stated this in our motion to disqualify. I don't know how clear.
Mr. Bias, not all people.
Yeah.
You have to talk to the microphone.
I don't know how clearly I stated this in our wherefore clause, and I may amend to make this very clear. But it will be our position that not only are we asking you to disqualify the entire Fourth Judicial Circuit, when the governor, I assume, does the governor's assignment for the new prosecution team, we're going to want all of the electronic data to be sent to a new filter team so that there is no way that this can happen again. So that the new state attorney that gets the case has it completely sent through a filter team so they don't end up with our text messages, our emails, our attachments, our timelines, and every other thing that the state had access to and is in possession of. So that's going to be another delay that the state can't burn the midnight oil on, because that's going to happen in our minds for this case to be secure and non-prejudicial to the defendants. All
right. Do you want to tell me what your position is based on the discovery that you conducted?
Our position is we're ready to go. With the exception of time that we need to get the transcripts from the depositions, so I would say 10 days. The state did speak with us this morning. Their timeline was acceptable in terms of our issue. You know, the bond issue is not our issue. That's Ms. Gardner's issue. Tangentially, though, it does affect, because what you're saying is, what if the state uses the document that I'm highly contesting, or the text messages that Ms. Gardner is highly contesting against Ms. Gardner in her bond hearing? That would pose a problem for me, because again, it would be one more person, you or anyone else, that would have access or actual knowledge of what's in that document. So I don't have a suggestion there, but I do have the same concern that you were sharing this morning. For certain, I can't predict what they may or may not show.
Okay.
And Judge, we are going to supplement our motion as the court asked us to inform the court today. And we're going to move to actually dismiss the indictment, Judge, based on the fact that the state and its law enforcement officers, and this is sworn testimony, were reviewing both Ms. Gardner's iCloud return and her Google Drive return before it ever went through the taint team, that was knowing and intentional acts by the law enforcement team that was working with the state. And that when they had questions when reviewing those about whether or not something they were actually looking at was attorney-client privilege, they would call Ms. Stifler and ask her, describe it to her, and ask her if what they were looking at was in fact attorney-client privilege communications. And so it's our position that the spillage of her attorney-client information throughout the law enforcement teams, which are Category A witnesses expected to testify in this trial, will amount to sufficient prejudice that we can never put the genie back in the bottle and Ms. Gardner can never get a fair trial. I will let the court know that we have some research to do. We are not taking this lightly. We want to make sure that we are able to adequately support the assertion that I just made to the court before we file our supplement. But we do think that what we established during the depositions this week, in fact, one of the things we learned, Judge, is that my client's iMessages from her iCloud, which we all know did contain attorney-client communications, were circulated to all or most of the primary members of the law enforcement team by email before the taint agent, who was never trained and had no protocol and had never done this before he even looked at them. And that the spreadsheet with all these messages that were circulated was open and reviewed. And that the law enforcement members did in fact identify attorney-client communications in that spreadsheet, which was by another court's order, right, in February of 2023. All of that was supposed to go through the taint agent before anyone that was part of the prosecution team looked at it.
Okay. So what do you all want me to do?
Judge, I would ask for 2 weeks for us to file our supplement to the motion to disqualify. I don't know how long the state would need to respond to that. And then
So that's still putting you off the timeline that you're indicating.
I know, Judge, but I'm stuck between a rock and a hard place. And so,
Do you want a moment to try to talk to your colleagues?
yeah, well,
Willie's client.
yeah,
not my client.
yeah, let me, one moment. Judge, I've talked to my client and we agree with the court's assessment earlier that if we can resolve the disqualification motion in a timely manner, we can then set the bond motion.
Okay,
And that satisfies the concerns that Mr. Fernandez has, Your Honor.
okay. And you talked to him about it? I mean.
We're in a different posture. I don't need to talk to
Yeah.
Mr. Fernandez.
Right,
He-
well, this is the thing. You all know, I have not seen one shred of anything, and before, this is the other thing I was gonna ask you, is it your thought, so you're gonna supplement, right? The state's gonna respond. Is it your thought that I do need to ask the chief judge to appoint another judge to review this material, or is there an agreement on it?
I spoke to the state and Mr. Carodi, and I'm just addressed for the record. I don't believe we need another court. The emails, the text messages, everyone and their brother had them in this case, far before Next Point even became an issue. And the documents that the state intends on using against my client, they've seen, they've read, they intend on using them. If the court, if you see that document, it makes no difference. That privilege has been eviscerated unwillingly by the defense. And I would say that if there was any concern for the court, I would waive any ability to recuse the court based on this very limited issue, because, if the court has some concern, like, well, then I'll see it and the defense will try to recuse me. Absolutely not. I think this court is the proper place to hash all of this out.
All right. Am I understanding? Before, there was an agreement that certain documents, certain communications, those things, my understanding was there was a great majority of the information that you all were talking about was agreed to by the state board, that was attorney-client privilege. Is that still the case? Or are you still, my understanding was only kind of one document or thing on Mr. Fernandez's part. But the state indicated it was evidence. The the defense said it was attorney-client privilege, and it was my understanding, it was only one contested document. Is that still the case?
There's
Right,
one,
so-
there's one contested document that the state is in possession of, admits that they've looked at and intends on using. That's what you're speaking of specifically.
Right, and so I'm
There are-
asking, is that still the case, yes or no?
Yes, there are hundreds of what the state agreed to were privileged communications that were uploaded to Next Point that the agents had access to. Their position is, yes, they were privileged, but no, we have never looked at them. No one has ever looked at them, albeit everyone had access to them. Their position is no one's ever seen them, except for the one document. So
Right, so I can clarify, sorry, I know, I don't mean to interrupt Mr.
You're
Geisler,
fine.
but I somewhat agree with what's being said. I do think that the depositions made clear, and that's been, the information brought out of depositions is the information contained in the state's filed written response. So we have been clear from the beginning, there was an agreement between parties to send cell phone devices, MacBooks, Apple Watch, and an iPad through a taint team. The Jacksonville Beach Police Department executed over 70 search warrants in this case, including to Google and to iCloud. They received that information directly as the affiant custodian of those records. Those records are at Jacksonville Beach Police Department, just like any other evidence for any case would be stored with the presiding law enforcement agency. There is one document that we discovered while reviewing this evidence that I believe is evidence. I don't believe it's one, it's a communication, or two, it's confidential, or in any way a privileged attorney-client communication. That document was brought to my attention by our analyst. I reviewed it. I determined that there was nothing about it that suggested it was from an attorney to an attorney, etc. I mentioned it to Mr. Dreiser, and we are disputing that one document. The rest of what they're talking about is the state of Florida never had possession of any of these items. They were in the possession of a law enforcement agency. Once we realized that there were attorney-client privileges, documents, or text messages on this information, which we had purposefully taken folders, left them sealed and zipped and didn't review them. The analysts were reviewing other evidence that was not attorney-client privilege. Those were then sent through the taint team. The state of Florida and law enforcement has never read any emails, any text messages, any client communications other than this one document. The state attorney's office agrees. I read this one document, I intend to use it. So I just want to be clear about all that because Mr. Kirby's saying he wants to dismiss the indictment and needs to do research to adequately support his assertions. I just want to be clear, at this point, they're assertions. We have no, I haven't seen their supplemental motion yet. I think I have previously said that the communications, I took Mr. Dreiser and Mr. Kirby, Mr. Geisler's word that whatever emails and text messages were privileged, I took their word that they were privileged. We didn't look at them, we removed them, we deleted them, we sent them through tape teams. To the best of our ability, we tried with good faith never to purposefully or intentionally read anything. Any disclosures or any possessions were inadvertent, and we took whatever steps to remediate our possession of these when we realized that we had things we were not supposed to have. in
Can
our
I
possession.
ask you a question? Do you believe, based on what Mr. Dreiser is saying, okay, that the court could just look at metadata and not the exhibit? Do you understand what I'm
I
asking?
understand what you're saying.
So so
I don't think you-
file, give me a second.
Yes, ma'am.
So file A, okay, if I don't need to see the contents of file A, that's why I'm asking you all this question. I don't see the content of it. If you all agree that it is in fact attorney-client privilege, there will be no need for the court to examine that document than to determine if whoever had access to it. That's what I'm asking. Are y'all agreeing or are you not agreeing? Or is the agreement just as to one document, or are you all saying it's multiple documents? And if it's multiple documents and there's no agreement, I'm gonna disagree with you, Mr. Dreiser. In an abundance of caution, I ask the chief judge to have someone else review it, settle your disputes, and then I'll look at the metadata.
And your Honor, my response to that would be, I have not seen anything or reviewed anything other than the document we're disputing is privileged. Two documents. Actually, one of them I reviewed, one of them I was told about the contents. I have not seen or reviewed any of the, I think he said 66.
it was also
emails.
sent to you in the same email,
Yes.
two
So
documents.
y'all will talk to each other. Is there an agreement or is it not?
It's a little bit more complicated. I know,
I'm not
I'm not, we're not in agreement that the one document that is going to have to be reviewed by the court. The
Okay.
other documents, which are emails, text messages, and phone calls, there are over 100 at least communications. There's no question that they're privileged, and there's no question that they were uploaded to NextPoint. The only and I wouldn't allow, it would be over serious objection by the defense that anyone ever get to look at those. So no court is ever going to get to look at
Okay.
those.
Give me a moment. Do you agree?
I do not. I believe that part of their argument, because my testimony and our response, and what I believe will come out of the hearing, is nobody from law enforcement and the state attorney's office looked at any of those items that they're talking about, the text messages.
I agree with you.
So why aren't you agreeing that they're attorney-client privilege?
Because I don't know what they say, and I don't dispute that there are communications between them and their clients. My issue is the prejudice, which is the second prong of their motion. If these emails and text messages are about scheduling, and the court's going to disqualify and dismiss an indictment because we had theoretical access that we could potentially hypothetically open a scheduling text message, I think the court needs to weigh that of how prejudicial the mere access is. Putting aside the fact that we didn't read them, the fact that I have a closed sealed envelope on a table next to me, it matters to me what's in that envelope because they're saying it's a communication. I'm not disputing that. I take them at their word. But what it contains is relevant to the remedy that they are seeking because they have to prove that they've been materially prejudiced in some way. The state of Florida has somehow inured a benefit to trial by having access to this information, that I will have evidence I should not have had, that I will have trial strategy I would have otherwise not known. So I believe that an independent magistrate should review it. And I will point out that when we had this agreement in front of Judge Carbula on their motion for protective orders to stop us from doing a forensic extraction of the phones, they were in favor of a magistrate reviewing everything. So at some point, we were all in agreement to detainting. They wanted a magistrate to review all the communications and remove attorney-client and marital privilege. The court said, no, the state can look at marital privilege. There was no court order. We agreed. We're not going to look at attorney-client privilege. We don't want to look at it. We have no intention of looking at it. Anything that has happened has been inadvertent and has not prejudiced them. So the contents of those messages are relevant to that prejudice, that finding of prejudice or non-prejudice.
With the exception of two documents
Yes, and I'm
titled
conceding that.
confidential communications sent by Miss Butler to Miss Stifler before the taint agent ever got a chance to look at them. And our expert's going to come in
I'm fine
here.
with the court reviewing those two documents because I don't believe their communications are privileged.
Our expert's going to,
They're contesting that.
and our expert's going to come into this courtroom and say that on such and such a date, Mr. Fernandez emailed our office and our attorneys only those documents. The taint agent is going to come in and say, had I seen the email with the attachments, they would have been privileged and I would have filtered them out. That's what we heard this week in the testimony.
All right. It is very clear to me that sooner rather than later, and when I say sooner, does Ms. Gardner share the same concern?
Judge,
With the same,
our concern is slightly different in that, you know, Ms. Stifler spoke about there was an agreement with the cell phones and somehow that agreement didn't apply to her iCloud that was seized after the agreement that everyone knows has the same text messages that are on her phone. And so I guess what I'm hearing the state say is that because law enforcement couldn't look at the phone, they went and got her iCloud.
I just want to clarify
okay.
about that. What I'm saying is, we had an agreement, we attempted to honor it, we were dealing with hundreds and hundreds and hundreds of megabytes of data. We did our best to send it through the filter team. We made efforts, extensive efforts to prevent disclosure of attorney-client privilege. The two documents he's referring to are just evidence. I had no idea they were emailed to Mr. Reiser by his client. I found them from an independent source. But I just want to be clear because they keep saying these things on the record that I dispute. And I just want to clarify the record. I think that we need an independent magistrate to review everything because I think that prejudice needs to be determined. And if Mr. Dreiser and I are agreeing whether the contents of this document are even a communication, then I'm not comfortable with your honor reviewing it.
I've said this from the outset. A court hearing a case of this magnitude, okay, I want to avoid any appearance. I appreciate the,
It's fine. We
I
don't object.
appreciate the thought expressed by you, Mr. Dreiser, but My concern runs deeper than that, okay? So I've said it from the outset, I'm the one that offered it. I've talked to Chief Judge Day, and he's willing to expend the resources. However, I'm going to request, it is very apparent to me that that is a necessity. And I am also cognizant of the time frame and the work that all parties have put into it, both the defense and the state attorney. That's why I need a clear understanding of where your agreements are, where your disagreements are, because I don't want to send this to another judge with you all still essentially disputing or arguing about what the magistrate is or the other judge is going to look at, okay? So, I'm going to ask the chief judge to appoint another judge to review these materials. I don't want to have access to it. I don't want to review it for a number of reasons. And I think it's only judicious and fair that if it is contested, what these documents are, whether they're privileged or not, a judge then ultimately, let's say we go through hypothetically an entire trial, there would be no way to, any imposition I would have, like I don't want to have access to something that apparently or may not rightfully be a part of this case. What I do need the parties to do is based on your discovery. So we have these initial motions. Ms. Gardner says she's going to amend. Mr. Dreiser, are you amending or no?
If I did, it would be of no real significance, just to make sure my remedy is clear and maybe add what we believe we learned in the depositions. It would not be of any significant,
Okay.
but I'll have it done whenever.
This is what I need you all to do. I need you to supplement both pleadings with what is in fact contested, okay? What is agreed to and not agreed to. The agreement should be, in my mind, the first part of the supplement. These now two documents that the state has admitted and then so that is the first part. The second part should be what you all do not agree to, what you want the magistrate to look at, so you can, out of this terabytes and terabytes of information, to hone in. And this is all for efficiency, and also if you want a decision done quickly, that you all kind of narrow the issues for the judge. I'm going to ask the chief judge to make the appointment. He should be able to do it hopefully by the beginning of next week. I need you all to supplement. How long would you all need to identify those things?
Despite how we're talking on the record today, I think for the most part, we actually agree on a lot of information.
I agree with that.
So
Oh, that's not the impression you've given me.
That's my morning report. Actually, Mr. Dreiser and I and Mr. Cody spoke this morning. I think a lot of these things there's little dispute as to certain pieces of the evidence. Our dispute is to the law and the remedy. So we will get together and we will come to some understanding.
Well, Matt,
What I'm understanding from you is that you want the magistrate or the judge to look at certain portions that you have not seen in order to say if it's to separate that these documents or these files or these, whatever it is, this is related to scheduling, therefore.
Right, I don't know what they are, but I think it is germane to their remedy they're seeking as to whether it prejudices them or not. The fact that I merely had access to their scheduling, I'm using that as an example because obviously I don't know what's in there. But it makes a very big difference if they're discussing their trial strategy versus if they're discussing scheduling.
From your deposition, were you able to kind of like narrow that down, or is it just hundreds and hundreds of files or things that were?
I narrowed the scope of the depositions to the documents that are in dispute. The other emails.
How about we start with that?
The other
What
email?
do you all think about that?
Here's the
Start
problem.
with that.
Here's the real next big issue with another magistrate reviewing all the emails, which in a vacuum, I don't have a problem with it. That magistrate, what Mrs. Stifler was referring to in the initial hearing, was going to be a magistrate, a special prosecutor, or a filter team person. I would have had no problem because they're totally isolated. And I assure you that person would have never reached out to Ms. Stifler to find out whether something was or was not privileged. But in this case, if the magistrate's going to do that, and the magistrate may have, or the circuit court judge, whoever Judge Jay appoints, and then has questions, the state attorney's office is going to have to bring in a special prosecutor to handle those hearings. It'll be like a federal castigar hearing where the AUSAs have a whole nother team to handle the hearing, because during that hearing, they would be potentially accessed or being asked questions or being asked to argue
Go
that,
back to my original question.
yes, you're,
What about, we start with the 2 documents that you all can test,
that's fine with me.
and then we table what Ms. Stifler is suggesting.
Sure.
Then you all don't have to supplement, you all can identify, we know what it is, right?
Absolutely. There's no confusion about those documents, who had them, when they had them, what they intend on using. That would be very simple for this. There still needs witnesses and a hearing to hear the timeline. But yes, we can absolutely start there and perhaps finish there.
That seems more prudent.
Yes, ma'am.
Do you agree?
I'm in agreement.
There we go. It happened.
Told you.
Where's Ms. Gardner in all this? Do you agree or no?
Yeah, Judge, we're going to supplement. I think our basis is going to be a little different. And that is, we believe that what we would call the state's effort, and by state, we mean the law enforcement team that's working with the state attorney's office, right? One state organization. That our concern is the effort to do an end around the court's prior order regarding the taint team by looking at the iMessages from the iCloud and the Google returns. So I don't think there's a dispute that there were attorney-client communications on, on those returns.
Is
And
this something that you discovered during the depositions?
yes, we had no idea. We had no idea that anyone had looked at her iMessages before the taint team or taint agent, because it wasn't a team, it was one agent.
Now I'm gonna ask you all this, to settle that issue, would you like another judge to hear that, or can you agree, or would you rather me deal with it through the metadata?
I think for that issue, based on what the deposition entailed with Ms. Butler, which this was outlined in the state's written motion, so to me, at least, it was not a surprise. She discovered an attorney-client communication while reviewing something and realized it hadn't been properly detainted, and then we sent it. That one communication, I think an independent magistrate could review. I never reviewed it, I don't know what it contains, but she could tell that judge in camera what it was without the state attorney's office present, and I'm fine with that.
Do you agree?
Yes, Judge.
Let me ask this, have both defense teams seen that? Do you want a separate hearing for each defendant, or do you want to have it concurrently?
When it comes to their messages, I don't know
So
what
you're
it
requesting
is.
separate hearings?
Yes, Judge.
All right.
Yeah, maybe, Your Honor, for judicial economy, a lot of the same witnesses, it may be the same hearing for evidence, and then just like a Castigar hearing, I would be asked to be removed for a portion of the hearing.
Obviously, I'm not going to conduct them, so I'm just trying to be as detailed as I possibly can with the request that I'm asking the chief judge to do, so that he can communicate and figure out who he would like to appoint. So what I'm asking, what would be required of the other judge, which is my understanding, which I'm gonna repeat back, is that you all have a contested document on Mr. Fernandez's behalf, two contested documents. And then on Ms. Gardner's behalf, there is a communication that was not, that was communicated to law enforcement. And
Two documents and one
communication.
message or text or something.
And I don't know exactly what the ATF analyst reviewed because I obviously did not ask her that in an open deposition. So it would be a questioning for the ATF analyst exactly what she has reviewed.
All right.
And because I know that the iMessages were circulated amongst at least 4 law enforcement officers, I do not know yet if any of them reviewed them also before the team agent was able to go through. In full disclosure to the court, we may stumble upon someone that's reviewed more than the ATF analyst.
You didn't ask those questions during the depo?
So,
How, if it was communicated to anyone else, or whether she talked to anyone else?
well, the problem is what she said is that she got the iMessages in an Excel spreadsheet that was emailed to her, and that there were detectives and other federal agents on that email. Obviously, she can't speak to whether or not those other people that were on that email did in fact review the iMessages. We've not deposed those individuals. I don't believe I've gotten a copy of the email that was originally distributed to know who exactly was on that email.
I don't, I can get it, I can make those people available. I will say, I mean, they can check them out, I don't have to take my word for it, but Ms. Butler was our analyst, so she was always the first and only person to receive and begin analyzing the evidence before everybody else did. So it's unlikely, but obviously I will provide those names and I'll get that email.
All right. How long, I'd like to do this sooner rather than later. Do you want to come back next week?
For the,
Or, so based on my understanding and the parties, Ms. Gardner is going to supplement, correct?
Yes, Judge.
All right. How long do you need for that?
Judge, I'd ask for 2 weeks.
Okay. In the meantime, I will ask the chief judge to appoint an independent judge from this case. When do you want to come back for your?
to set, all we need really is the 10 days for the transcript.
When did the depo occur?
Tuesday and Wednesday.
There really wouldn't be a need for me to see you all. The appointment can be made, and then the scheduling would be with the other judge. I can put this on for status.
Yes, ma'am.
Yes, Judge.
So you need 2 weeks. You need time to get the transcript, which it looks like, by my count, the earliest the transcript would be ready would be February 29th. If I count 10 business days, if you ordered it.
We did, and Miss Butler chose to read. I don't know how that delays or not.
Okay. So would you all be prepared to supplement without the transcript or no?
Judge, I believe we would based on my notes from the deposition.
Okay. What does your scheduling look like in early March, so I know when to bring you back for status? What I'm saying is you would appear in front of the appointed judge, okay, to review. I'm assuming that judge will need time in order to process and, do an order. I can come back
March 4th.
March 4th, anytime that week, or the week of March 11th, you can let me know where you are with the other judge. If you want me to do that, or, I was just gonna set this for a status at this point.
March 4th for a control date to see where we are with the other judge would be fine with the defense teams, Your Honor.
Yes, Judge.
Okay.
Can we do March 5th? The co-defendant is set to appear in court.
I'll reset his date. You want the 4th?
Yes, ma'am.
I just set that as a status, on the Tenon case, knowing that, these cases would dictate a court date for him, okay? So we, on both, Mr. Fernandez and Ms. Gardner, we will come back on March 4th, 9 a.m. status hearing.
I have one clarification. Mr. Carodi is requesting the names for the email with the spreadsheet because we're in this situation. How do you want to receive that? I'm not gonna ask that they forward me that email because they're contesting that it has privileged communication on it. So
I would imagine like a PDF or a printout and scan of the email itself that just shows the attachment would
She's
not.
asking you, she doesn't want to get it and give it to you.
Right.
How do you want to get it?
Ms. Butler can just forward it to me.
Okay, I'll have her do that.
Judge, I don't know that the email itself would be privileged. It's the attachment that's privileged. That was just the point I was making.
How do you know it's in it? I thought you haven't seen it.
I haven't, but the way it was described to me was it was just forwarding an Excel spreadsheet with the iMessages in the Excel spreadsheet.
If you'll have,
Yeah. That's fine.
the agent forward directly. Okay.
And then lastly, Your Honor, the motion for our mitigation specialist to go to the jail, we're working directly with the general counsel from the city and the chief of the jail to resolve this issue. And I believe that we're going to be able to self-resolve it.
You are, okay,
I think so.
all right. Anything else we need to take up?
No, ma'am.
No, Your Honor.
So, obviously, when the chief judge makes his appointment, that will be communicated to the parties. I will see you all back on March 4th, 9 a.m. for status of both cases. Thank you all very much.
Thank you, Your Honor. May we be excused? Thank you.
Can you guys hear me? Let me know. If y'all can hear me, we'll stay here. Okay. Great. Okay, so you guys can hear me. It's not ideal. I also don't have a microphone. My travel mic isn't working, so these are my ear pods. It's working okay? Okay, great. I want to share with you guys about what came out last night. Thanks for being with me. This is my travel setup. I'm at my mother's apartment and just, well, we'll wait. Let's listen to let's listen to any hot mic, see if we can hear anything. Hold on. I sound better than they did. Great. Courtroom sounding clearer now. Okay, there goes Mario. In his jail garb. Okay. We'll stop screen. Hey everyone. Okay. So I'm gonna read to you guys. We're gonna pull up some documents that came down last night. I am traveling. I'm taking care of my mother, so it is an assisted living facility, so a nurse might come. I just want to apologize if there's any distractions, because we're going to get through this together. Hold on. All right. So what came out yesterday was kind of a big deal. It was part of the probable cause. They had to show this. So let me show you what we have here. Let me pull this up. And as I pull this up, I just want to share again that it was really interesting. I would call this a win for Jose Baez that, um, he was able to get Shanna Gardner in street clothes, where Mario Gardner looks like he's not represented by Jose Baez, and he was not in street clothes. Nobody clearly requested that for Mario, and it's definitely setting these two apart. I would call that a win for Jose Baez. It'll be interesting how he plays it. Of course, there's no jury now; it's just in front of the judge, and of course, we're all watching it. But those things they've proven through research do affect juries and people watching. All right, pull this up. Share screen here. Here we go. Can we see this? Okay, let's see how to make it. Okay, I'll go make it large. Okay, I'm gonna start reading this. Let's just read it together. Well, I read it late last night. I read it late last night, actually about 4 or 5 hours ago. And this will help explain a little bit more about the hearing. Authorization for application to circuit court for an order approving the interception of wire and electronic communications. So in other words, they intercepted and essentially tapped the phone of some people, and they're trying to get approval for the interception of this electronic communication because they think it's a big deal and they want to be able to use it in court. So in the Circuit Court of the Fourth Judicial Circuit for Duval County, Florida. All right. And it's signed by Melissa Nelson, state attorney. Next page. This is interesting, guys. Trust me, this is interesting. Probable cause affidavit in support of application for this interception of communications. Over the course of the past 11 months, defiant, and do you guys know what an affiant is? It's, for those that don't, it's the person who authored this affidavit, who swears to the truth and accuracy of the statements made in this affidavit. The affiant has developed a probable cause to believe that the target subjects, Henry Tenon, that's the hitman, Mario Fernandez Saldana, and Shanna Gardner, redacted. So who's that other person, comma, and redacted? We have an active criminal investigation, hence the redaction. They have conspired together to commit the homicide of Jared Bridegan. Wait, what? Right? This is why this is a big deal. Did you guys catch that? So these subjects, Henry Tenon, he is arrested, the hitman. Mario Fernandez Saldana, that was Shanna Gardner's husband at the time, and Shanna Gardner, both of who you saw in court today, as well as redacted. We haven't heard of this until this moment. They have all conspired together to commit the homicide of Jared Bridegan. And that redaction is so long. Can you guys see that? That I suspect it's two people. And the news has said pretty much the same. Jacksonville, Florida, Channel 4 News came out and they stated that it looks like 5 people are possibly conspired together. Oh, so we have 2 more people. This case just keeps getting, I'm telling you guys, the more that comes out in this case and then discovery, the weirder it becomes. So they have conspired together to commit the homicide of Jared Bridegan, participated and or planned in the homicide of Bridegan, aided or assisted in evading law enforcement during the investigation into the homicide of Bridegan, lied to law enforcement during the course of the investigation, and tampered with evidence. Defiant has probable cause to believe that Gardner, Shanna Gardner, will utilize target telephone 7 to discuss the details of the case, including her theories of the homicide, information relating to the charged co-defendant, Henry Tenon, and information regarding her potential plans to flee. Gardner's inside knowledge of the conspiracy, her potential covert or encrypted communications with Fernandez Saldana or his attorney, plans for further encryption or attempts to invade evade interception, knowing, hey, that in other words, evade interception of the phone calls, meaning, hey, my phones are probably being tapped. I want to evade this, or the types of methods of covert communications, third-party applications, etc. Affiant will discuss in detail in this affidavit, but in summation, Affiant believes there is probable cause to believe that Gardner will communicate with redacted regarding the case on target telephone 7, because Gardner and redacted, by the way, target telephone 7, we're going to learn who that is in just a minute. So target telephone 7, because Gardner and redacted have been discussing the case and the arrest of tenants since the intercept began. Gardner has repeatedly mentioned that she does not feel free to discuss these matters as she believes her phone may be tapped, yes, or that law enforcement is watching her phone, yes, and tracking her. During the conversations regarding Henry Tenen, Gardner and redacted have suggested using a different phone. Gardner previously did have a secondary phone. Oh, we've got a regular Lori Vallow here. She has a secondary phone. And then she reactivated her secondary phone or moving their conversations to FaceTime. Gardner specifically discussed with this redacted person whether FaceTime screens could be recorded. Gardner also mentioned that when she went to her therapy session, she left her device outside the room so that she could talk without paranoia. Now we're going to go to the next page, but I'm going to come over here to StreamYard to make sure. Is everything still working? Identical charges for both Gardner Fernandez. Thank you, Stephanie May, for being here, and CC and all my mods. Okay, so my mic's still working. I can keep reading. All right, here we go. So here, if you guys wanted to know who target telephone 7 is, we're about to learn. Affiant has learned from the intercept that Gardner's sister, Sage Hupiani, or Hupiana, forgive me if I got that Hawaiian last name wrong, Hupiana, will be staying with Gardner from Thursday evening 2/2/23, so last year in February, a year from now, a year ago, through Sunday 2/5/23. That redacted person and Gardner had a conversation on February 1st, 2023, that Sage could call redacted person's husband over the weekend. Affiant will play the recording for this court, and it is incorporated as an exhibit. Affiant believes, based on his knowledge of the tone and tenor of their conversations and the context of the conversations, that this was a plan for Gardner to use Hupiana's phone to talk to redacted so that they can discuss the case freely without interception, recording, tracking, or etc. So let's get into who the subjects are. Who is Sage Hupiani? Well, she is Gardner's older sister. Throughout the course of the intercept, Redacted has had multiple conversations with TT2. That's the targeted phone 2. That's Gardner. So TT2 means Gardner's phone, Shanna Gardner's phone. So Sage and Gardner have had multiple conversations through Gardner's phone referencing the need to have family members, to include Sage, with her in Washington State to take care of her minor children should a major case development happen. I'm going to pause. This is Lauren. We have heard from reliable sources that as the investigation went on, that the Gardners made sure to always have somebody in Washington just in case Shanna was arrested. That's what we've heard. And that they were always flying back and forth and taking turns being with Shanna so that the children wouldn't be given to state's custody and that they would be able to automatically take the twins. So that's what we had heard. And so when I read this, I just want to say, oh, that looks like it is accurate. We've never shared that before, but there you go. So it sounds like Sage and Gardner have had conversations with her in Washington State about taking care of her minor children should a major case development happen. Sage is believed to be flying from Utah to Washington on Thursday, May 2nd, 2023, and staying with Gardner until Sunday, February 5th, 2023, so a few days. And based on the analysis of toll records obtained from T-Mobile TT2, again, Gardner's phone, and Sage, They've had no historical cellular communication from January 2022 to present. Sage's historical communication with targets in this case is limited to text messages with TT1. That's Fernandez Saldana. That's his phone. So Sage's historical communication with targets in this case is typically text messages with Fernandez Saldana or Mario on April 28th, 2022 and July 11th, 2022. Sage texted Fernandez Saldana's phone. And additionally, in January of 2023, Sage contacted Fernandez Saldana and engaged in a text message conversation about social media, vacations, and drug use. Conversation started with Sage telling Fernandez Saldana that Gardner believes the two of them, meaning Sage and Fernandez Saldana, can still be friends. Sage and Mario discussed plans to meet up in Texas to smoke something. Based on this conversation, the affiant believes Sage is attempting to maintain communication with and maintain her relationship with Mario. And we learned that this drug here is a hallucinogenic drug right there. Thank you for that asterisk. Oh, wait, shoot. Okay, here we go. Forgive me. Okay. We're going to go back to not my touch screen so that I don't do that again. So B, who is this subject? So first off, look, it's a very long redaction. Can you see that? For those that are only listening, it's a very long redaction. B, this is another subject. I'm going to, I don't know if that's one or two names. Let's find out. The shorter name is a longtime friend of Gardner. This redacted person has had an extensive historical relationship with the Bridegan family, actually, and has known victim Jared Bridegan since he was a teenager. After Gardner and Jared Bridegan's divorce, this person became close to Gardner. Records obtained from T-Mobile show extensive communication between this redacted person and Shanna Gardner, including over 400 voice calls from January 1st, 2022 to December 2022. So in 1 year, 400 voice calls. Guys, think about that. There are 365 days in a year. This is 1 year, 2022. And they talked over 400 times. That means more than once a day for an entire year. That was the year Jared was murdered. That's wild. This person that allegedly knew Jared Bridegan and then became besties with Gardner, talking to her every day. The average duration of these calls is 16 minutes. So that's not a high and by either. Call records also show the communication between this redacted person due to this active criminal investigation and the phone of Mario include text message exchanges in March, April, May, and September 2022. A review of the Google search warrant obtained for Fernandez Saldana's account shows both this redacted in his Google contact list. A review of law enforcement database showed redacted are married. So now, okay, so now we know that these two people are likely married. So that there are two people we're referring to here, and they're married, and they share the same address. A review of records and the data obtained from the register and the trace for this person was regular communication between this person, both redacted. However, records show that neither Mario nor Gardner's phones have had any communication with redacted from January 1st, 2022 to present. So I assume that means the spouse. Further, a review of redacted records does not show any communication between redacted and Sage from January 2023 to present. Based on the absence of historical communication between redacted and Gardner, as well as the lack of historical communication between redacted and Sage, the affiant believes there is no existing relationship between redacted and Sage that would explain the context between them or explain Gardner and redacted's statement that Sage should call redacted or that Sage and redacted should catch up. So they're just explaining why they think they're giving a probable cause as to why they think Sage doesn't have a relationship with these people. Oh, you guys, the struggle is real. Okay. So here is TT1. This is Mario Fernandez Saldana. And here are the number of calls. Did I miss a page? Let me just double check. Oh, travel issues. I apologize, everyone. Travel problems. But we're here. We're here. Is that where I left off? Okay. Oh, I'm so glad we didn't miss this. So at the bottom, I'm not going to zoom it in because I keep messing up. At the bottom is activity during the wiretapping, the wire intercept, showing who Shanna Gardner called and so there are 9 calls to redacted. There are 6 calls that they caught to the Intrepid Group. That's the public relations firm that the Gardner family allegedly hired. Now we can pretty much confirm they indeed did. 5 calls to Linda, the media relations specialist, Linda Lucetti. 4 calls to Marla. As you guys remember in the body cam footage, Shanna does state that she needs to call Marla to take the kids, and then her mother interrupts and says, her mother, Shelly Gardner, says, "No, Shanna, I'm here. Don't worry about Marla." And a lot of people thought that Shelly was Marla because of that exchange. Marla, I believe, is a next door neighbor. She's a friend, neighbor, and employee of Shanna's. There are 3 intercepted calls to Shelly Gardner, her mother. 2 intercepted calls between Richland Police Department and 1 between Officer Martinez from the Richland Police Department. Gardner has received a total of 30 calls that were deemed pertinent during the duration of the wire as of February 2nd, 2023. Redacted, there are, so redacted, redacted. There are significant conversations between the two discussing alternate theories of the homicide as well as other pertinent subjects, which will be discussed further in the affidavit. And then B, the Intrepid Group and Linda Lucetti. This is the PR firm that the Gardner family hired. Again, they didn't hire like a PI after Jared was murdered. They hired a PR group. Gardner's public relations firm. Several of the calls include both Chris from the Intrepid Group and Linda Lucetti. Most of the conversations are in reference to what their response will be to the announcement of the arrest and plans Gardner should make. They suggest Gardner take a vacation or check into a hotel under a fake name. During one of the calls, Lucetti offers that maybe a gay lover was the killer. Wow. Wow. Here are significant statements by Gardner in one of the calls on January 25th, 2023. But guess what? It's the majority of this really important phone calls redacted. But C, Marla Rogers, a friend of Gardner's who owns a home bakery and lives next to Gardner. The calls are in reference to reporters being in the area of their homes and making contact with Rogers. Kelly Gardner, mother of Shanna Gardner. Their calls are in reference to the media and what to do. Shanna Gardner also stated she is going to stay in a hotel to get away from the media. Richmond police officer Gardner wants officers to place barricades at the end of the street to keep media out. Here are some calls that are of interest in this affidavit between Mario's phone. He makes 2 calls to Carlos or Sonny. He makes 1 call to Adriana Gonzalez, 1 call to Brandon McDonald, and 1 call to Ruthie Corsi. Fernandez Saldana has received a total of 5 calls that were deemed pertinent during the duration of the wire as of February 2nd, 2023 at 1600 hours. Pause. All right, back. So who is Carlos that Mario calls? a friend of Mario's who calls to ask him about Henry Tenen. He offers an alternate theory about why Tenen may have committed the crime, stating that he did it because he got kicked out of Mario's rental property and he mistook Mario for Bridegan. And then, Fernandez Saldana, Mario states that he and Henry Tenen know Tenen was working for me for a bit, like after the homicide, helping me take down trees, moving and roofing. This friend asks if Henry Tenen knew anything about Shanna's ex-husband, and Mario stated that no, he didn't. He stated that the immediate law enforcement are going to paint it how they want to, as a three-way split being this guy, Henry Tenen, and Mario, and Shanna. So in other words, he lays out what's going to happen. They're all going to be arrested. Adriana Gonzalez is Mario's sister who lives in Jacksonville. They were speaking about the media finding Fernandez Saldana in Orlando, and they might attempt to come to her house as well. Brandon McDonald is a voicemail from an unknown caller, and Ruthie. Most of the calls are in reference to military benefits. We do know that he wanted to receive military benefits and be disabled. During the end of the phone call, they talked about Mario having a legal team, but he is worried about being stereotyped. It's interesting, too. Mario is worried about being stereotyped, and I think that is actually happening. He is the one that's not in street clothes, and Shanna is in street clothes, and I think that's certainly probably the Gardner's plan is to have him stereotyped. Gardner and redacted activity during wiretap. Oh, it's all redacted. No. On January 23rd, 2023, there's some super important phone call that was intercepted, and it is all redacted. It's between Gardner and Mario. Based on the client's knowledge of the lack of relationship between Redacted and Sage, as well as the knowledge of Sage's planned trip to Washington and the tone in which the above conversation took place, the client believes Redacted and Gardner are planning to communicate with each other through, guys, I think this was supposed to be redacted. Do you see it there? Anyway, Sage's devices will be a deliberate attempt to conceal the communication from law enforcement. Wyatt is familiar with the tone and tenor of Gardner's conversations. When Gardner and Blank were discussing Sage should call Redacted and should catch up, the tone was clearly indicating that Sage and Redacted were not the individuals who would be using the phone. Law enforcement contact with Redacted. On May 6, 2022, Jacksonville Beach detectives Jason Lamont and Chris Jones interviewed Redacted in respect to the homicide of Jared Bridegan. In summary, Redacted informed law enforcement she had known Bridegan and his family for about 20 years. Redacted advised she went to church with Bridegan, but was not friends with Bridegan. Redacted described Bridegan as a quiet person who only dated girls with money, but would act like a jerk to those he dated. Redacted advised she was really good friends with Gardner, clearly, since they talked every day or twice a day, and stuck by Gardner during Gardner and Bridegan's divorce, clearly. Redacted described Bridegan as just a jerk who would not interact with the kids and only leave his room when dinner was ready. After the divorce, Redacted stated Bridegan would quit his job anytime Gardner asked for child support. Redacted described Gardner as a great mother who worked 3 jobs to support her children because Gardner's parents stopped supporting her. And Redacted believed Bridegan was only interested in making money. Redacted believed Redacted believed Gardner and Bridegan would both be happy with more custody of the children, but were following the parenting plans. Redacted believed when Gardner first met Mario, she thought Gardner did not need to be with anyone. Redacted reported she did not know Mario, but found him to be very direct and did not appear to be a very nice guy. Redacted commented on Mario's stature and believed it was weird that Gardner and Mario married so quickly, but knew Gardner wanted to appear to be in a stable relationship. Oh, so she gives a motive for the marriage. Redacted does not believe Mario was the marrying type and was not in love with Shanna. Oh, so that's interesting to me. She actually believes that Mario was not in love with Shanna. So why did Mario get married to Shanna then if he wasn't in love with her? Maybe it wasn't Jared that was the one after money. Just share. When Redacted was questioned about Bridegan's murder, Redacted brought up that Bridegan was a Freemason, that Bridegan was always about money, and believed the murder was in regard to a money thing or involved the three Freemasons. That's a new one. Redacted also advised the thought Bridegan's current wife, Kirsten, might have had something to do with his death and might be positioning herself for a wrongful death lawsuit against Gardner. What? When Redacted was asked about her thoughts on the comments in the news articles that alleged Gardner and Mario's involvement in the murders, Redacted stated she did not see it and that she had been Gardner's side for 8.5 years. Redacted, talk about picking the wrong side. Redacted stated Mario Fernandez Saldana hated Bridegan, but would not give up his pushy life by killing Bridegan. When law enforcement asked Redacted if Gardner would stay with Fernandez Saldana if he was involved in the murder, Redacted stated Fernandez Saldana would be gone due to putting the kids at risk. Redacted advised she spoke with Gardner after speaking with law enforcement to schedule the interview. Redacted stated she and Gardner discussed the scheduled interview, giving DNA but nothing out of the ordinary. On January 30th, 2023, at approximately 16:32 hours, Jacksonville Beach Detective Jason Lamont contacted Redacted to request a follow-up interview with her, the Jacksonville Beach Department, but Redacted did not answer. Affiant intercepted the following activity. Redacted had a 2-minute data session beginning at approximately 16:34 hours, followed by a 4-minute session beginning at approximately 16:36 hours. Beginning at Redacted and Gardner. So this friend and Gardner began having a lot of sessions in close proximity to each other, indicating to Affiant that they possibly were communicating via a third party. Boom. So in other words, all these calls that didn't happen on Shanna's phone, probably because there was a third party involved and they were communicating in other ways. On the same date, at approximately 17:50 hours, Redacted contacted Detective Lamont, who requested to call her back. On the same date, at approximately this many hours, some developments in the Brightigan homicide investigation agreed to meet with Detective Lamont, and the interview was set for Tuesday, January 31st and January 30th, 2023, at this hour. And he had an outgoing call to her husband, Redacted, that lasted 21 minutes. On January 31st, 2023, at approximately this time, Detective Lamont called Redacted and advised her of a family emergency and that she needed to reschedule the interview for Friday, February 3rd. Redacted agreed to meet with Detective Lamont on the newly scheduled date. Oh, so now she's avoiding talking to police. Pause really quickly. 1 second. All right. Can you guys hear me? Okay. At the end of the intercepted call between Redacted and Gardner's phone on February 1st, Redacted suggested that this weekend maybe Brad should call Sage. Further, Gardner responds, I like that. Redacted continues, they should catch up. This sounds like code. These statements are made in a manner that is markedly different in tone and pace from the rest of the call as previously discussed. Such changes in the conversation are unable to be understood from transcripts of the conversation, but it is clear the affiant that both parties are communicating in a deceptive manner to disguise what is believed to be future communication between Gardner and Redacted. As detailed above, affiant has no knowledge of any relationship between Redacted and Sage that would require the parties to catch up. Further, Gardner has had no communication with Redacted during the course of this investigation. Therefore, affiant believes it is unlikely that Redacted and Sage will be communicating on this proposed phone call. The timing of this proposed phone call then aligns with Sage's planned visit to Washington State that is scheduled for February 2nd. Additionally, as detailed above, Redacted is scheduled to be interviewed by the Jacksonville Police Department on Friday, February 3rd at 11:30, based on the amount of historical contact between Redacted, and Gardner surrounding significant events in this investigation to include law enforcement's interviews. Defiant believes Redacted will share details of the interview with Gardner and potentially openly discuss facts related to the homicide. This is based on Gardner and Redacted's belief that law enforcement would be unable to intercept the communications because neither phone that would be used to communicate is directly associated with Gardner. Wait, should I go back? I think I missed some stuff. In summation, the evidence as outlined above by Affiant establishes probable cause that the target subjects were and continue to be involved in conspiracy to commit the murder of Bridegan, evade and mislead law enforcement regarding the murder of Bridegan, and alter, conceal, or destroy evidence relating to the murder of Bridegan. Affiant has probable cause to believe Gardner and the other target subjects, Fernando Saldana, will use or otherwise communicate with Target Telephone 7 regarding their involvement in an effort to evade law enforcement. Affiant has based this knowledge on Sage's planned visit to Washington, the lack of relationship between Redacted and Sage, prior communications between Redacted and Gardner about their attempts to conceal communication from law enforcement, and Redacted's scheduled interview with law enforcement. Affiant believes that Redacted and Gardner will be using Redacted and Sage's cellular devices to make the proposed phone call. I swear the facts included are true to the best of my knowledge. So again, I apologize. This is choppy. I don't have a mic and I'm traveling. So I'm going to take off. But essentially, what that probable cause affidavit was the state saying they need this call. And they were laying out the evidence why it's important. They believe that calls were being made on Sage's phone to avoid interception by being wiretapped. So they want these calls with Sage's phone between Shanna and Sage. They do not believe that Sage knows these other people and that this was sort of code for Shanna to talk to Sage and to avoid being wiretapped on her phone and to use Sage's phone for calls. So in other words, Shanna wanted to use her sister Sage's phone for calls while she was in town to avoid being wiretapped. So they want to get these phone calls made on these dates on Sage's phone. Sage is Shanna's sister. Thank you, Colette. I'm going to take off. I think that was probably a super choppy reading due to all the redactions. The redactions didn't help. But in summary, they want these phone calls off of Sage's phone because they believe Shanna was using Sage's phone during the time that Sage was in town. Makes sense. All right, everyone. I think the biggest thing, though, from that, although it's interesting that they want these phone calls, we now know that there are 2 other people involved that they are looking at. There might be more arrests in the future. To be determined. To be determined. All right, everyone. I'm going to go help my mama. Okay. We'll see you guys. Have a great day and we'll see y'all soon.